Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an awesome Christmas Eve. It is raining here in Dallas, and I'm just, I guess, parlaying today. So I was like, why not do some content? And I wanted to go live versus making a video because I don't know. Every time I do like a pre-recorded video, it's choppy and stuff like that, and I don't know how to fix that. So I was like, let me just go live. So I think this is best. So it's not going to be a long live. It's just kind of updating you guys on what you see in the title. So if you have been following, TD Jakes has filed a lawsuit against Duane Youngblood. And Duane Youngblood is an individual who is a felon. He has been known, charged, and prosecuted and has served time for messing with underage boys. He is a registered ex offender, all kinds of stuff. And the biggest thing is that he is known for extorting pastors and trying to get money from them. In a way, blackmailing, saying if you don't pay me this amount of money, then we're going to sue, and that is why we are here. Once again, all civil complaints are allegations until the petitioner actually provides supporting document to the courts. Good morning, Buttercup. How you doing this morning? And Merry Christmas. I know that my in-laws, they start Christmas early. So Feliz Navidad to anybody out there that's celebrating today and tomorrow. I'm part of that crew. Uh, Good morning, Slay. You have to inbox me and tell me how to pronounce your name. Is it Slay or just SLA? Because I don't know. But let's hop right on into this. Like I said, it's not going to be a long one. So if you've been following this, then this is an update for you. So, oh my gosh, you got to go back and watch the other live so you guys can understand where we're at. So, TD Jakes, Pastor TD Jakes, or Bishop, I should say, filed a lawsuit. They ended up serving. They had trouble serving Dwayne Youngblood because they were under the impression that attorney Tyrone Blackburn, if y'all been with me, y'all know who Tyrone is. Tyrone was, I believe, he sent the letter to TD Jakes, the extortion letter, or what they call a demand letter. And so they reached out and say, "Hey, are you willing to accept service for Dwayne Youngblood?" And Tyrone was like, "No, y'all just need to go ahead and try to get him served." So Youngblood ended up getting served on December 4th or 5th, I believe, which would make his response to the lawsuit due on the 26th of December. Now, he has since then filed his motion or an application to extend his time to respond to the lawsuit, and a motion to strike it, saying that he only works part time. He doesn't have enough money to pay for an attorney and all this other stuff. So in between time of that, TD Jakes ended up filing in kind of like an urgent request to the court to obtain records from Larry Reed. And if I've never knew who Larry Reed was prior to doing this, so I did go over there and kind of look at to see what was going on. So in the process of Dwayne trying to get time to respond to the lawsuit, TD Jakes is trying to get information from Larry Reed, everything that he knows from business records, anything about his company, like everything, his computer parts to see all of the shows that he's did. So pretty much TD Jakes is trying to recover or uncover, not recover, but uncover all of these people here. So In a sense, Larry Reed, as well as Attorney Blackburn, are considered co conspirators in this madness. Because Larry Reed has put out there that he's seen the extortion letter prior to it even being sent to TD Jakes. So you do have some type of knowledge about what's going on. So it could be a possibility that you have knowledge of who these other John Does are that are trying to come after him. And good morning, Mercedes. Merry Christmas Eve to you as well. All right, so hopping into this, this is about 7 pages, but the exhibit, I don't know. There's an exhibit, but I don't know what the exhibit is in relation to. I don't read this in its entirety, so I like to give my raw reaction when I do read this, but I do scan it to ensure that there's nothing presented that shouldn't be presented to the public. So here we go. So this is TD Jake's opposition to Duane Youngblood's application for extension of time to respond to the complaint and motion to strike pursuant to the Federal Rules of Civil Procedure Rule 12F. 12F. All right, so we have plaintiff Thomas Dexter, what is it? Jakes. That's TD Jakes. Hereinafter plaintiff. Hold on, let me do something right quick. Da, 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 da. Let me see. Okay, so to kind of give you guys an idea of what 12F is, hold on, I'm gonna do that first. Hold on, let me put my paralegal browser up. I should have had my Westlaw up, but that's okay. Because everybody probably like, what is Federal Rules of Civil Procedure? Federal Rules of Civil Procedure 12. Yeah, I can understand. All right, let me share. Where is it at? Here we go. Okay, I'm gonna go to my Westlaw. Hopefully, it doesn't require me to sign in. All right, so a practice, da 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 da. All right, so this note explains when a court may strike an insufficient defense or other material from a pleading when a party must file a motion to strike grounds of the for the motion and alternatives to the motion. This is really saying how to. What is another good one? So pretty much Rule 12F allows the court to strike redundant. Don't do this to me. Well, isn't that nice? Because I don't like this and it ain't gonna tell me. Okay, I guess this is gonna have to do. I don't want to donate. Let me out of here. All right, so 12 A B C D E F. All right, so here it is. So 12F is the motion to strike. So the courts may strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. The court may act on its own or by a motion that is filed made by a party either before responding to the pleading or if a response is not allowed within 21 days after the motion is served. So that is what Duane is trying to do. He is trying to strike certain things from TD Jake's complaint, but we all know he has to have a motion in order to do that. First and foremost, though, Dwayne's gonna have to respond first before he try to do anything. All right, so let's get into this. Hey, what's up, Tiffany? Good morning, good morning, good morning. All right, so going back. Blah 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 blah. So that is, I'm gonna reread this so now we understand what the Rule 12 is. So plaintiff TD Jakes, buying through his undersigned counsel, files this opposition to defendant's Youngblood's application for extension of time to respond to the complaint in this case, and he makes a motion to strike scandalous and absolutely false material pursuant to, because when Duane responded in regards to getting more time to respond to the lawsuit, he also made claims. You remember those pictures that we seen, just trying to make the court believe that he does indeed know who TD Jakes is. TD Jakes did do what he did back in those days. And so that is what TD Jakes is referring to by filing that motion to uh strike that response that Duane gave. All right, so I hope that, ooh, excuse me, I hope that is understandable from this point. Good morning, Latice. How you doing? How you doing? How you doing? All right. So simply, defendant Youngblood's submission to the court by letter dated December 20th, 2024 constitutes a responsive pleading as construed by the federal rules of civil procedure and should be deemed as such. Defendant Youngblood's 11th hour application based on a purported need for additional time is nothing more than a delay tactic to further coordinate with his co-conspirators by creating a mechanism to avoid dealing with plaintiff's motion for expedited discovery, and as a general matter, move forward with the case. So, to improperly lob salacious, false, and irrelevant material at plaintiff. For these reasons described below, supported by the declaration of attorney Darrell Janey, this delay tactic should not be content, and that's correct. And it is a delay tactic, because he put in there he can't afford to pay an attorney, and he has, oh yeah, and he tried to use the freedom of speech, he is talking about his experiences. This is not scandalous, this is not defamatory, it's none of this. These are my true experience and I should be allowed to talk about it. Therefore, I am saying that my First Amendment rights are violated. I have freedom of speech. That's what he's trying to throw in the air. All right, so here's the relevant factual and procedural background. Something that I kind of told you guys at the beginning, but this will explain where we are at now. So, as this court is aware, the complaint in this case was filed on November 25th, 2024. Counsel for plaintiff made a couple of attempts to coordinate service of the complaint and related papers on defendant Youngblood with the person then purporting to be defendant Youngblood's counsel, attorney Blackburn. Even though counsel for plaintiff offered defendant Youngblood an opportunity to waive service, which in return would have permitted him 60 days to respond to the complaint, defendant Youngblood responded, "Chase me if you dare." Defendant filed his first rejected Defendant first rejected that offer on November 25th, and then again doubling down on his antics when counsel for plaintiff iterated its offer on December 4th. Ultimately, plaintiff was able to achieve service on defendant Youngblood on December 4th, more than a week after filing the complaint and following successive requests to coordinate that would have given the defendant more time. So, what they're saying is, if not defendant Youngblood, if attorney Blackburn would have accepted service on Duane Youngblood's behalf, that would have given him 60 days to respond rather than the I don't even know how many, however many days between November 5th and November 26th. So he would have got, but attorney Blackburn said no, and defendant Youngblood simply state, "Just chase me." I mean, he's saying, find me and serve me. So what Jake's attorney is trying to do is he's trying to shed light on, he had an opportunity to get more time to respond to the lawsuit, but he shot that down. Buying through his gamesmanship, defendant Youngblood failed to obtain the time he now seeks. We submit that defendant Youngblood should not be rewarded now for this brazen and apparent arrogance. Prior to successfully serving defendant Youngblood directly, counsel for plaintiff received several emails from defendant Youngblood's counsel on December 4th. He talking about attorney Blackburn. Those emails articulate a plan to, among other things, file an anti-slap motion against plaintiff and secure several affidavits under penalty of perjury to be used against Bishop Jakes. So you're telling me prior to them filing a lawsuit or December 4th, whichever date, Attorney Blackburn was acting in the capacity of as his attorney, but now all of a sudden you're not his attorney. This does not make absolutely no sense. That's why I said Tyrone be doing some shady stuff. And I hate the fact that he is the attorney for some of these cases against DJ Academics and against Diddy, because your track record is making everybody, like the plaintiffs, you know, you're like basically discrediting the plaintiffs in other cases because you're doing shady stuff like this. Like you've been working with Duane Youngblood from what I have been doing research for. That's crazy. The plan described in counsel's December 4th emails in sum and substance are no different than what defendant Youngblood describes in his response to the court in his current submission. On information and belief, even though defendant Youngblood describes his status as pro se, meaning that he's representing himself, Attorney Blackburn continues to work with and advise him as counsel. In part, we submit that is the reason defendant Youngblood carefully states that he is in the process of attempting to retain a local counsel. Because remind y'all, he's in Pennsylvania, and I do not believe that Youngblood is licensed to even practice law in Pennsylvania. So he may be getting legal advice, but Blackburn doesn't know the jurisdiction for Pennsylvania. I don't know. I believe it's a stall tactic, like they said. The issue is not that defendant Youngblood suffers the need for counsel. Rather, on information and belief, the defendant is facing a two-pronged problem. First, here's the first problem. On information and belief, attorney Blackburn is having difficulty getting sponsored by local counsel to support him for the admission in the Western District of Pennsylvania, given an admonishment by federal district court judges in response to counsel's conduct. I What case was that? Oh, and it's going to tell us anyway. So let me keep reading. And that is in Janie's declaration. So, for example, on April 3rd, 2024, Judge Denise Coate, district judge in the Southern District of New York, this is the judge, the Southern District in which the Diddy cases are being filed in, so the District of New York, the Jane Doe with Sean Carter, all of them. So the district judge in Southern District of New York referring Attorney Blackburn to the grievance committee of the Southern District of New York. I remember that. Issued an opinion in order stating a reasonable interference from Blackburn's pattern of behavior is that he improperly files cases in federal court to garner media attention, aka remember the Little Rod case. That's when that was like the first case I seen pop up. Then I seen the case with DJ Academics. I was like, yeah, this man is trying to gain some attention from us. Embarrass defendants with salacious allegations and pressures defendants to settle quickly. Indeed, his submissions to the court have been rife with disturbing allegations against defendants and defense counsel. All right. So, what they're saying here is attorney Blackburn can't be um defendant Youngblood's attorney because he can't even so the way that it works, like I said, he's not licensed. I'm not sure if he's not licensed in PA. He could be licensed, but when you're dealing with the federal court, you have to have admission, and you have to no, he isn't. I have to look. I have to look because it says sponsored by a local council for to support him for admission in the Western District. So I don't even think that he is actually uh licensed to do that. I need to look that up. But the thing is, no local council in the state of Pennsylvania want to work with Blackburn, because in order for him to even take on Duane Youngblood's case, he has to get with local counsel, file a pro hoc vice, and then he will be able to represent him that way. But because you didn't had this grievance filed against you, and then so many other people are reporting you, you can't help nobody. So now that's what I'm trying to figure out. Is that the reason why nothing's moving with the DJ academic cases? Because those are filed in New Jersey. And nothing has been done since September on one case and July in another case. And discovery does not take that long. So Blackburn out here doing shady stuff, and he is a plaintiff's attorney out here working with this man here, Duane Youngblood, who's known for extorting pastors, and you're associating your stuff with him on top of you being shady, trying to extort defense counsels on the back end. It ain't looking like, dude, you're right. You you rose and you fell all in the same week, Mr. Attorney Blackburn. I need to look at all his cases and see what's going on, because that right there alone is content. I've always had my suspicion about Attorney Blackburn, always. All right, so the second thing is that on December 17th, 2024, plaintiff filed a motion for expedited discovery, requesting approval from this court to issue two third-party subpoenas, which in turn are anticipated to reveal the identities of John Doe's in this case and further substantiate plaintiff's conspiracy claim. By December 18th, 2024, based on assertions by defendant's brother, Richard Youngblood, on a public podcast, defendant Youngblood was working tediously to provide his response to the court to the allegations made in the complaint, and that the public could expect that answer within the next week, as the deadline was December 26th is approaching. We submit that what changed between December 18th and December 20th is that defendant Youngbloods and his co-conspirators needed to find a way to slow down the proverbial train. Oh Lord, they talk about flash flood warnings. According to defendant Youngblood's response followed on December 20th. So, all in all, from what I have gathered that we have already read, is that Attorney Blackburn had the opportunity to accept service on behalf of Duane Youngblood, which would give Duane Youngblood 60 days to actually respond to this lawsuit. However, Attorney Blackburn refused. Duane said, "Catch me if you can." Now he has been caught. His answer was due on the 26th, but now he has filed an application to ask the court to give him enough time to respond to the lawsuit, because he doesn't have money for an attorney. He works part-time and he's having trouble finding local counsel. But Attorney Blackburn is having trouble finding anybody in the PA to sponsor him because he got a shady background. That's what I've read so far. All right, so here's their argument as to why time should not be given to him, and as to why uh that motion to strike needs to happen against his whatever response that he submitted with the court about his First Amendment rights being violated. Let's hop on into it. Defendant Youngblood's response constitutes a responsive pleading within the meaning of Federal Rules of Civil Procedure 7A because it engages with a substantive issues raised in a complaint in response to the merits. It is no mere request for an extension of time to secure legal counsel. Rather, first, defendant Youngblood specifically argues that Bishop Jake's complaint is without merit, and then he proceeds to identify affirmative defenses to the complaint itself and that he did. So it's like you're asking the court for more time, but yet you're responding to the allegations in the complaint. I would treat that as a response. Specifically, in pertinent part, he states, Your Honor, I have unwavering confidence that the court will discern the lack of merit in plaintiff's claims, which I firmly believe constitute a violation of my First Amendment rights. He does not provide a mere conclusion assertion. Rather, the defendant cites and then elaborates on case law in support of his protected speech defense, including New York Times Company versus Sullivan. So then you go on to cite a case, but yet you're still asking for more time. If y'all hear the rain, baby, it is raining. But you are asking the court to provide you with more time to respond, but yet you're responding. This is clearly an effort to provide notice of his intended defense and the basis in law for his argument. Here, in this respect, defendant Youngblood and his counsel, Attorney Blackburn, is trying to comport with the Federal Rules of Civil Procedure Rule 8 by articulating our affirmative defenses as to the reasons Bishop Jakes should not win. This is the very heart of a responsive pleading. You responded to the lawsuit already, stating that your First Amendment rights were violated. In addition to his protected speech defense, defendant Youngblood raises the specter of affidavits in support of his truth defenses to the libel claim. Further, in his 6-page submission, and it was 6 pages. If you're just asking the court to buy you more or like to give you an extension, that should have been 1 page, 1 paragraph. That's it. You provided way too much information. So it's funny if they say, "Oh, you've already responded, my guy. We're not going to allow you more time, but we shall see." Further in his 6-page submission, defendant Youngblood articulates and elaborates upon the reasons he should fall within a heightened protection under the First Amendment because Bishop Jakes is a public figure. Ooh, child, it's thundering outside. Moreover, he raises the affirmative defense of waiver in accordance with Federal Rules of Civil Procedure 8C. For example, defendant Youngblood states, despite my consistent and public recounting of these incidents, Mr. Jakes did not see fit to file a defamation lawsuit against me during any of those years. This inaction suggests that Mr. Jakes himself recognized the validity of my statements or deemed them unworthy of legal challenge at the time. That's his second response. Again, this sort of elaboration and detailed reply, while erroneous and ineffectual in this case, is the nature and substance of a responsive pleading. Given that defendant Youngblood has submitted an answer to the complaint, in which he did, I totally agree with that. He did. He replied back to what Jakes put in that lawsuit. Therefore, that is a response to the lawsuit. But yeah, you need more time. So Attorney Blackburn should have advised him just to say, give me more time. That's it. Sign your name and file that. But you went into a whole combative tune in this document. Given that defendant Youngblood has submitted an answer to the complaint, the clock should not stop on the procedural mechanisms that then follow under the Federal Rules of Civil Procedure in order to move this case forward. For example, we submit that Rule 26F initial conference should proceed, and whatever motions defendant Youngblood intends to bring forth can be discussed with the court at that time without pre prejudice 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 without why can't I say that? Prejudicing the plaintiff by, in effect, postponing the day of reckoning for likely 30 to 60 days. So, what they're saying is he's already filed his response to the complaint. Let's go to the next step. We got to have a status conference hearing to see how we're going to, give some deadlines on this and that. You already responded, my boy. Boy, if the judge rules that, I know Duane and Attorney Blackburn gonna be they're gonna be scared. I don't see, I see this case. This is about to be an interesting case. Defendant Youngblood's shameful assertion that Bishop Jakes is responsible for. Oh, what? I didn't even read that part. Hold up. Defendant Youngblood's shameful assertion that Bishop Titty Jakes is responsible for unaliving should be stricken. That's why. That's why he wants a freaking motion to strike that. Where did he say that at? Defendant Youngblood states, upon information and belief, Bishop Jakes and his family have a they did say that. All right, let me reread that. Upon information and belief, Bishop Jakes and his family have a reputation of having individuals who challenge them or expose their dirty dealings disappear throughout the years. Okay, I remember them saying that on there, and then they showed a screenshot of the son, TD Jakes' son, I guess inboxing Duane Youngblood and pretty much telling him that he shouldn't do that. Baby, that's crazy. I forgot about that. That's why TD Jake's attorney is asking for a motion to strike that part, because that is incorrect. That's not factual. They can't prove it. There's no supporting documents whatsoever. So that should be striked from the record. I agree. This statement can only be characterized as an allegation that plaintiff has been engaged in violent criminal activity, including unalivings. It should be stricken pursuant to Federal Rules of Civil Procedure Rule 12F, and I already went over that. And that rule permits courts to strike any insufficient defense or any redundant, immaterial, or impertinent or scandalous matters in a pleading, including an answer. That makes sense now. Such motions are granted where the allegations have no possible relation to the controversy and may cause prejudice to one of the parties. Here, the bald faced lie that Bishop Jakes has participated in making people disappear is scandalous at its core. It has no relation to the libel and conspiracy claim in this case whatsoever. In conclusion, defendant Youngblood's application in reality is a Trojan horse simply intended to undermine the litigation process in this case. If permitted, the application would result in substantial prejudice to the plaintiff for the reasons described herein above and within the supporting declaration. Accordingly, we submit that the application should be denied. So, two things that's happening here. They're asking for they're asking the court for Duane Youngblood's, I'm about to say Dwayne Wade, Duane Youngblood's request to extend or grant him enough time to respond to the lawsuit. They're requesting that to be denied because really it should be constituted as his actual response to the pleading. That's number one. Number two, if they do go ahead and accept that as his response to the lawsuit, they are asking for that section that talks about them, making people disappear to be stricken from that document. All right. So I hope everybody is with me. Um, let's see. Oh yeah, so I already talked about the what you call it. Now this exhibit is let me see. Let me go back. Where did they talk about exhibit A at? Let's go. Uh do 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 do. Defendant. Da, da, da. Now I could have sworn it says something about Exhibit A, and it doesn't. That's weird. All right. So Exhibit A, because I did review, this is the opinion in order for a case that is in the Southern District of New York, and Blackburn is actually a the plaintiff's attorney on here. And this is the opinion from the judge of this court. Oh, yeah, I remember saying that in the opposition. So it says Attorney Tyrone Blackburn filed this action asserting that jurisdiction exists pursuant to Title 28 of the USC, Section 1332. He did so without conducting a reasonable inquiry to support that assertion. Because this filing appears to be part of a pattern, he will be referred to the court's grievance committee. So this is so in the document that we just read, remember when it was talking about how Blackburn has been referred to the court's grievance committee. This is on this particular case. Girl, I got it, Kimmy. That's gonna come up in a few. Once I get off of here, I'm about to hop into that. So I'm gonna go live probably at 12 on that one. So definitely come back. And thank y'all for, telling everybody to hit the like button. Y'all definitely don't forget to hit the like button. Yes, we do have members only content. Join the group. That's how you guys support. All right, so let's see what this man has been doing. Tyrone Blackburn. So, plaintiff filed this legal malpractice action on December 14, 2023, against defense attorneys Lane Fisher and Michael Taubenfeld and their law firm Fisher Taubenfeld LLP. He did so after being advised by defense counsel that complete diversity of citizenship did not exist because the plaintiff and defendant Fisher are both domiciled in New Jersey. I'm trying to figure out. Ooh, on February 9th, defense counsel requested an immediate conference to discuss inter alia, adverse counsel's abusive tactics, and the lack of subject matter jurisdiction. Defense counsel submitted the December 15th email she had sent to Blackburn, repeating her representation to him that the defendant Fisher is domiciled in New Jersey. In response, Blackburn filed a notice of voluntary dismissal as to the defendant Fisher on February 9th and objected to the request for an immediate conference. Blackburn explained that he had voluntarily dismissed the action as to Fisher, even though defense counsel had not produced evidence of Fisher's residence. The dismissal of Fisher did not solve the question regarding jurisdiction. However, since defendant Fisher Taubenfeld LLP takes the citizenship of its partners, I'm trying to figure out. The order also listed by docket number 5 other actions Blackburn has filed in this district that has been dismissed for lack of jurisdiction or transferred or dismissed for lack of venue. See, this is he and I've seen this in also whose case was that? I believe it was Sean Combs' case where he filed in one district and also in DJ Academics. He filed in New York, filed then ended up filing a voluntary dismissal because he was in the wrong jurisdiction, and then ended up filing it in New Jersey. I don't that's not even a strategy here. I don't know if he's not doing his due diligence to see, because I remember it was one of the Sean Combs case where the action didn't even take place in New York. The action took place in New Jersey. So he's not doing his due diligence before he's even filing, which is a total disservice to the plaintiff. Look at this. Blackburn also presented a description of 5 cases which he had filed in this district, but which had been dismissed due to the lack of jurisdiction or change of venue. Blackburn, and here this is the judge's decision. Blackburn has, as he admits, failed to meet this his Rule 11 obligations in this case. It appears that this is part of the pattern. With not just this particular case, there are so many cases that Blackburn is on that I don't know what the heck he's doing. The court declines to impose sanctions pursuant to Rule 11 or its inherent power, but will refer him. So what they're saying is that they're not going to have him pay attorney fees and all this other stuff, but what they will do is refer him to the court's grievance committee. There is a basis to believe that Blackburn is filing cases in this district without diligently investigating the existence of either jurisdiction or venue as required by Rule 11. This man has a problem. Federal Rules of Civil Procedure 11B states provides that by presenting a pleading, written motion, or other paper to the court, an attorney certifies that to the best of his knowledge, his or her knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, it is not being presented for any improper purpose, such as to harass, that the claims and other legal contentions are warranted by existing law, and that the factual contentions have evidentiary support. Yeah, I'm not reading all this because of 16 pages, but what are you doing? And his excuse, Blackburn asserts that he relied on 2 sources of information in deciding that Fisher is domiciled in New York, his client and a LexisNexis search. He asserts that his client told him that Fisher lived in New York. See, I honestly, I don't know. I'm clicking off of this because that's pissing me off. That's really pissing me off. I've said this time and time before. I don't know if attorney Blackburn is new to the legal game, but one thing you never do is you have to, when you do an intake, right, of your plaintiff, and if they know the whereabouts of the defendant, then you verify that information. I use LexisNexis. I also use public data. I also use TLO. So I have 3 databases that I make sure that I find the correct address for the defendant. One, because you have excuse me, you have to serve them. That's part one. You have to serve them. Part two is you have to how and I told this to you guys before. How you determine which jurisdiction to file in is based on where the defendant lives, or it depends on where the acts occurred. So if it went down in New Jersey, then you file in New Jersey. Okay. It just depends on what type of case it's going to be. But they said that this individual lived in a certain place, but yet he still ended up filing in the wrong district. I don't know. I have to do my more research on Blackburn because this man is fishy. He is very fishy to me. Um, and to be associated with Mr. Duane Youngblood in this particular case, I don't think that it's going to work out. I think Jakes is going to be able to move along with this case because one, Youngblood has responded, and I don't know why Blackburn didn't tell him or advise him, not to submit a 6 page, document or responsive pleading in response to the freaking lawsuit. That right there is going to be acknowledged as your response. You're not going to get a response. You're not going to get that time to respond to the lawsuit because you already responded to it, my boy. Ooh, baby, that thunder just scared me. But yes, Dwayne, you have submitted your answer to the lawsuit, And I think that the judge is going to go ahead and accept that. And they're going to strike the allegation that you said that they make people disappear, and they're going to move along with this case. So you better get ready. That's all I got to say. You better get ready, my boy. But yeah, so that's just an update on that. TD Jakes is not playing. The attorney is, doing what he should be doing. And as they stated, and they requested the court just go ahead, treat this as an answer, and let's move on to this case because this dude is stalling. So I hope that they are able to get those subpoenas out and to Larry Reed so they can find out who because here's the thing. Yes, we are going to, and I'm saying hypothetically, they are going to accept that response from Dwayne Wade as a response to the lawsuit. They're going to strike the alleged disappearance of people, that language from the document. But the case is not going to be able to move forward unless they get those names of the John Does that are also included. And for them to get that, that is why Jakes filed the motion to expedite discovery and saying, hey, can we get these subpoenas out to Larry Reed so we can hurry up and move this case along? Because once they get that information from Larry Reed, and it does include information of the identities of those John Does, they can amend the complaint and they can carry on with the case. That's all. It's as simple as that. So y'all tell me what y'all think about what's going to happen with this TDJ uh Jake's lawsuit. Can't even talk. Do y'all believe that the court will possibly grant Duane Youngblood an extension, or do y'all think the court might go ahead and accept what he submitted as his answer or response to the lawsuit? Because I believe that the court is going to rule with Jake's on this one. But y'all tell me what y'all think about it in the comments below. Don't forget to like, share, and subscribe. Thank y'all for tuning in. I'll be back probably at 12 with the update for the Meg. I already pulled the documents, and we'll get into that at 12 p.m. So I will see y'all later. Be blessed. Stay warm out there. Bye.